If the bank refuses to release statements, what legal steps can be taken to compel production of the records? In a probate situation, the usual legal tool is a court-issued subpoena that requires the bank to produce specific documents. This works best when your request is tied to an open estate matter, such as a year's allowance petition, because subpoenas are generally issued in connection with a pending proceeding. If the estate is before the Clerk of Superior Court, and especially if it becomes a contested estate proceeding, the clerk can apply civil subpoena and discovery rules and can enforce compliance. Practically, that means you file the appropriate petition in the estate, request a subpoena for production of documents directed to the bank, and make the subpoena specific. Identify the accounts, the date range for statements, and the ownership and survivorship records you need, like signature cards or titling documents. The subpoena must be properly issued and served, and it must give a reasonable time to respond. If the bank objects or asks the court to limit the request, you may need to narrow it and explain why the records are necessary for the probate issue you are asking the court to decide. If the bank still does not comply after proper service and any objections are resolved, the next step is to ask the court in that same proceeding for an order enforcing the subpoena and compelling production, with appropriate protections for confidential information. Timing can matter too. If a personal representative has been appointed and you are seeking records to support a year's allowance, there is typically a 6-month deadline after letters are issued to file the verified petition, so it is important to act quickly while you pursue the records.